Rivers, he's the criminal lawyer. Who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And he's gonna react to all the self-snitching.
Hello, welcome to another episode of Criminal Lawyer Reacts. This is Bruce Rivers, board-certified criminal defense lawyer, where I offer reactions to rap music. I give commentary, try to tell you young guys what to do and what not to do and how to do it. And also want all you to know that we are really killing it, and we have a field trip coming up that can't tell you exactly what it is right now, but this is just what we call a tease. And we're gonna have some fun with this field trip, and you guys it's gonna knock your fucking socks off. If you have socks on, get ready to have them knocked off. Anyway, today we are reacting, or actually giving you a little bit of news today. We're gonna talk a little bit about Pop Smoke, a little bit about Lil Mosey, and kind of also do an analysis of the George Floyd situation with all the 4 officers, and how this new federal indictment it plays into it, and a little juror intrigue. So let's get right into it. Pop Smoke, as you know, was murdered. We talked a little bit about that in one of our prior videos. He was murdered by 4 people, and when he was in the shower and they stole a watch. Well, last week he was Mr. Corey Walker, one of the only adult among the 4 people. The other 3 are all juveniles. But Mr. Walker had a preliminary hearing. What's a preliminary hearing? A preliminary hearing is where the court determines whether there is probable cause to proceed. And all that means is that they have a hearing to determine whether or not there's enough to get to the jury. Now, this happened a year ago, and so it's been a year to get a preliminary hearing, which I think is outrageous, because usually you're supposed to have your trial within 60 days of your finding a probable cause. But in any event, Mr. Walker had a preliminary hearing, and an officer testified. Now, at the preliminary hearing, all the state has to do is show that it's more likely true than not true that a crime was committed, and that the defendant committed that crime. So that means it was that's the definition of probable cause. So the officer gets up there, and he basically, normally when you're in court, you can't use hearsay. Hearsay is what somebody else said. But in this case, he testified to what the woman that was at the house told him in an interview. And what she said was 4 people came in through the upstairs window. They held her at gunpoint and said, "Shut the fuck up, do you want to die?" See why I don't like the word "shut the fuck up"? I just don't like it. But in any event, so they held her there at gunpoint. They went into the shower. They heard pop. He falls to the ground. They take off, steal some jewelry. Then Pop Smoke, or Bashar Jackson, runs downstairs. She hears 2 more pops, and he's laying dead on the floor. So the officer also testified that Walker's plate number was they got that from the security footage, and he had been pulled over before this happened on something completely unrelated, and he is looking at the death penalty. So this is a very big case out in California. So so there we got the and the whole death penalty part of it is a completely different animal. Don't have enough time to go into that right now, but as we follow this case, we'll definitely go into that and let you know what that entails. So the judge now will have to make a ruling on whether there's probable cause to proceed, and most certainly that there is. One of the things that a defense sometimes uses a preliminary hearing for is to kind of test the veracity of the evidence. It's a very low bar, probable cause, but the defense sometimes will use that hearing in order to kind of get more information about the case and to kind of test the veracity of the witnesses and the people that are testifying, whether it's a cop or somebody else. Usually cops testify at those. Okay, and it's a death penalty case, and it's just tragic that you have 4 young individuals, 3 of which are juvenile, that did this for money, just for the bling. Anyway, I know we talk a little bit on this channel about gang violence. I don't think this was a gang type thing. It might have been, I don't know. But it's just sad that people, are going to rob somebody just for their dough. Go get your own fucking dough. You got a dream? Do you have a dream? I bet you do. Well, you go get your dream. Look at me. No one gave me a goddamn thing. You get your own stuff. And then you don't have to look over your shoulder, except for maybe for some shithead who wants to steal your shit. So anyway, that's just a little proselytization. So let's talk about Lil Mosey. Lil Mosey, Lathan Moses Eccles, that's his name. He pleaded not guilty, and this is a criminal sexual conduct case. And they issued a warrant for his arrest, and they were asking for $50,000 in addition to what he probably already posted, because he didn't show up for court. Well, they sent the court notice to a wrong address he had lived at for 5 years, and the state figured out, okay, well, we better withdraw that request. So the judge let him travel, and they withdrew the request, and now the case is probably back on track. This is a case where the woman we call them accusers. I don't call them victims. I call them accusers. Some of these people are hangers-on, and they just want either their day in the sun, or they want to see if they can extract a payday or whatever. And I don't know the facts of this case, in detail. I know a little bit about it because of what's been said in the media. And what it's been said in the media is that, they had a preliminary hearing in that case as well. And this woman testified, or the cop testified, that she said she initially gave consent in the back of the car. He pulls his pants down and they're consenting. And then she blacks out. And she blacks out only to wake up in the residence. And when they woke up in the residence, she's being assaulted by 2 individuals. And so when I say assaulted, I mean she's being fucked by 2 guys. Okay, first of all, guys, and we almost never see this with women. Criminal sexual conduct is almost always men. I've had very few cases where it's been a woman. We did have one case a while back, and this woman was giving her best friend's child a blowjob, and who was 15 years old. And I told the judge, I said, Judge, I don't think it should be a crime to give a young lad bragging rights and put a smile on his face. Be that as it may, I have a bit of a double standard. In this case, Eccles and a guy by the name of Prater were banging her, and she's out like a light. Guys, first of all, you shouldn't be banging a woman with your buddy, especially if she's passed out, because it's just bad form. It's not gentlemanly. You really want to watch your buddy screwing somebody? I mean, I just think that's kind of a turnoff. But notwithstanding that, it's just bad. It's illegal. It's just fucking illegal. A woman's got to be able to say yes. And if she even comes close to saying no, the answer is no. And not only no, but fucking hell no. You cannot cross that line. But here's the other thing that's interesting about this particular case. Lil Mosey was under 18 when this happened. And they investigated this case for 15 months. And this is not a case where there's a delayed report. Sometimes there's a delayed report where somebody doesn't report something to the cops for a long time. That's not the case here. And the cop investigated this case right off the bat, very early on. And so the defense kind of is at a little bit of a loss when that happens, because there's things you can do right away that you can't do maybe 15 months later, and memories fade. And so that's kind of an issue for that case. I I do like one of the things I like from a defense perspective in that case is that she initially gave consent. In Minnesota, we just had a third-degree criminal sexual conduct. That's when you have sex with somebody who is incapable of they're under the influence of something. And they just overturned that whole statute saying, on a particular case, saying that it has to be administered by somebody other than herself. And if it's self-administered, in other words, you're drinking on your own, it's not third degree. Okay, that's Lil Mosey. So we got a murder, crim sex, and now let's talk a little bit. Let's move to the George Floyd situation. Now, as you know, Derek Chauvin was convicted of everything. He was convicted of murder 2, murder 3, depraved mind, and manslaughter in the second degree. Let's just talk about sentencing for a second before we dive into everything else. On the sentencing part of this, the state has filed a motion for an upward departure. In court for sentencing, a court cannot depart from the guidelines unless there are aggravating factors. And you have the right. It's called Blakely is the name of the case. It was a federal case. And in Blakely, the court said you have the right to have a jury trial on whether or not there are aggravating factors that would justify an upward departure. An upward departure means something outside of the set guidelines, okay? The guidelines for this case are about 150 months on a murder 2 unintentional. So that's 12 and a half years. However, and what they've done in this case is that they've waived their right to a jury on whether or not they're to prove the aggravating factors, and they submitted it to the judge in writing. And I don't think the judge has ruled yet as to whether or not their aggravating factors exist. But he's going to say they exist because you got children present, you've got failure to render aid, and a bunch of different other things that they've asked for. So if the judge issues an order saying that there are aggravating factors, well, then that gives the judge permission or the authority to give a sentence above the guideline range. And what do they usually do? Usually a double upward departure is generally the standard. And I bet that happens here. And in this case, that would be 300 months or 25 years. So that is my prediction on the Chauvin sentencing. But what has happened since? A couple things have happened since. Number one, the Derek Chauvin has asked for a new trial. And one of the grounds, they asked for everything under the sun, and which they should. And I think it was a good motion. But one of the things that they've asked for is a motion based upon juror misconduct. Now, a juror in this case went to D.C., and a photograph surfaced of him being at a George Floyd rally in D.C. And when asked on the juror questionnaire, have you ever attended a George Floyd protest or rally or something? I don't know exactly what the wording was, but it was specific to Minnesota. Now, which I think is on the defense lawyer a little bit for not exploring that further. And I think narrowing it down to Minnesota was a mistake. Because in this case, the juror I believe it was in D.C. So you have a juror who gave a truthful but misleading answer. And that, I wouldn't have kept that juror. I don't think any defense lawyer would. In fact, I bet you could probably have gotten rid of that juror for cause. And so that will be an issue on appeal. So they will file an appeal after the sentencing, and there's all kinds of grounds for an appeal in this case. Whether it actually sticks or not, we have a very, very conservative Supreme Court, and I just don't know. If anything that they throw up there will stick. Now, what else has happened since the verdict? Well, the federal government, as lovely as they are, has decided to indict, that's what this is, all 4 officers with civil rights violations. Now, my theory on why they did this is because I think they're concerned. Well, first of all, it's political. The federal government has to show that they're doing whatever they can to be on the right side of history, right? But I also think that they're a little concerned that the other 3 officers stand a chance of getting acquitted of the state charges. And let me tell you why I think that. First of all, Tu Tao, he is the Asian officer who is doing crowd control. Everything's happening behind him. I bet he gets acquitted, both of this federal indictment, and I bet he gets acquitted in the state court case. I know all the lawyers. First of all, it'll be if all 3 defendants are tried together, it's going to be a completely different case. You've got 3 lawyers who are just top-notch lawyers. Not to say that Eric Nelson isn't, but Eric Nelson was by himself. I know these 3 lawyers. They're all working together, and they're all kick-ass lawyers. But you also have some facts here in these 3 lawyers' cases that you don't have in Chauvin. Chauvin's the main actor, without question. But like Tu Tao is, everything's happening behind him, and he's got people coming at him. He's diverted. I mean, he doesn't know what's going on back there. And then you've got Lane, Thomas Lane, who's got an amazing lawyer. He attempts to say, shouldn't we turn him over? In other words, should we put him on his side? And he's only 4 days on the job. The other thing that they're going to have to, and King is holding his leg, so he's got a less of a chance of getting acquitted. But here's what they have to show. They have to show now in count 1 of the federal indictment is only about Chauvin, and it's a deprivation of rights under the color of law. And in fact, that's what I believe. Let me see. Yeah, they're all for deprivation of rights under the color of law. But one of the things they have to show is that they were aware of the, they willfully failed to intervene to stop Chauvin. And, if you have a statement by Lane saying, shouldn't we turn him over? That's an attempt to intervene. If you have somebody whose back is to the action, he's got to knowingly fail to intervene. He's got to know what's going on behind him. So I think the only one that really stands a greater chance is Chauvin and King of getting convicted. But they really have a different burden. It's still beyond a reasonable doubt, but what they have to prove is different than in the other case, in the state court cases. So, and the penalty phase of this goes out the window because it's, the maximum sentence is life. And I don't know that a judge would necessarily give life on a case like this, but mark my words, they will get a much stiffer sentence in federal court than they would in state court. And there used to be a serialized prosecution law in Minnesota where if you were charged in state court with something, they couldn't charge you in federal court. They've gotten rid of that. But one might ask, isn't this double jeopardy? No, it's not double jeopardy, and here's why. You have the state of Minnesota and the United States of America, 2 different sovereigns, okay? Just like you can be charged in Minnesota for a drug crime, and you could be charged in federal court with the same drug crime. They generally don't do it, but this is such a high-profile, highly political case that they basically are charging the same conduct in federal court. But the rule is that the sentences would run concurrently. So that is a quick update of the Pop Smokes case, Lil Mosey, and the 4 officers charged with the murder of George Floyd. So I appreciate you guys listening. follow us on Instagram, follow us on Twitter, and we're doing great work on Patreon. So if you haven't signed up for Patreon, you're missing out. It's a chance to do some good. So we'll see you next time, and keep an eye out for our field trip, because we are doing something really cool, and I think you guys will freak out once we do it. So thanks again.